Do you think that Hillary Clinton fixed her election and there was co-conspirators? You mentioned Spitzer.
I don't believe that she fixed her election. I believe that the media fixed the election as they fixed the elections of Eliot Spitzer. Each of these public officers ran in 2006. Eliot Spitzer ran to be governor, having been Attorney General for 8 years. Senator Clinton ran for re-election to the Senate. Each of them breezed to re-election because the public was not informed of their records of corruption in office, and as a result, those elections were not remotely competitive.
Was the media informed? Did you sue the New York Times?
The media has been fully informed over the years of what Eliot Spitzer and Hillary Clinton have been doing, but have not reported. Knowingly, deliberately, and the situation with the New York Times reached such a level of fraud on the public that, yes, we have sued the New York Times, a litigation ongoing. It is the first lawsuit ever to be brought against media for journalistic fraud, and specifically election rigging. And what we have said is that as a pattern in practice, the New York Times does not report honestly, accurately, as to the processes of judicial selection and discipline, the corruption of these processes. And the corruption of these processes involve public officers, and among them has been Eliot Spitzer, Hillary Clinton. Their record has gone unexamined, not just by the New York Times, but the other media as well, which is why I'm here. So now you want to know something about the evidence.
Yep.
And what Senator Clinton has been doing. Well, I should identify first that everything that I say is fully documented, and the documentation is posted on our website.
Which is?
Which is www.judgewatch.org. That's the website of the Center for Judicial Accountability. There is a sidebar panel entitled Press Suppression, and you can see in a special topics section a topic as to the press protectionism of Senator Clinton, as well as other public officers, but specifically Senator Clinton is what we're talking about here. There is also a sidebar panel, Elections 2006, informing the voters, and you can see how her ability to run for presidency was shaped years ago, including in 2006 when she enjoyed a landslide victory over her Republican opponent. That was, again, engineered by the press, because the press would not report on her record in office with respect to judicial selection and discipline. Okay, so now let's get to specifics as to what you will see on the site.
If somebody that doesn't have a lot of knowledge of law, how would you explain the magnitude of what Hillary Clinton did wrong? You know, in simple terms, what did she do wrong?
She's a public officer. We have elected her to safeguard our rights and our welfare. As a senator, she has powerful responsibilities. For example, this is clearest, perhaps, with respect to federal judicial selection. Federal judges are appointed by the President, but they are approved by the Senate with the advice and consent of the Senate, and the process goes through the Senate Judiciary Committee. But even before the nomination is made by the President. There are behind closed doors deals made by the senators with the President to secure nominations. And in 2003, a nomination was made of Richard Wesley to the Second Circuit Court of Appeals. Richard Wesley was a judge on New York's highest state court, the New York Court of Appeals, and he was nominated by the President of the United States, and the background to that nomination is shrouded in total secrecy because notwithstanding our home state senators, Senator Clinton, Senator Schumer, purport to have some sort of process of screening, they will not divulge any information as to how it works, who is involved, but they were contributors behind the scenes to this nomination, which when it was announced, we immediately advised each of the senators, as likewise the Senate Judiciary Committee, of the serious and substantial nature of our opposition to his confirmation to the federal bench. This opposition rested on his corruption, demonstrated corruption in office, sitting on the New York Court of Appeals in two important public interest lawsuits involving the public's rights. One of those lawsuits was a lawsuit which I brought to the New York Court of Appeals. It was a lawsuit suing the New York State Commission on Judicial Conduct for corruption.
What did you bring to Washington, D.C. That caused you to be, you were arrested by the Capitol Police in Washington, D.C.?
That arrest was set in motion by Senator Clinton directly.
Why?
Well, what I brought to Washington was the evidence of what Judge Wesley did on New York's Court of Appeals in the two public interest cases, and specifically, and most importantly, in the lawsuit against the New York State Commission on Judicial Conduct. Let me just identify what the New York State Commission on Judicial Conduct is. New York State Commission on Judicial Conduct is the only agency in New York State that is charged with the duty of receiving and investigating complaints against New York State judges. And what we had spent years documenting is that the Commission on Judicial Conduct, rather than investigating the complaints that it is by law required to investigate against state judges, dumps them without investigation. And so we brought a lawsuit, a public interest lawsuit, against the Commission on Judicial Conduct, suing it for corruption. That case went all the way up to our state's highest court, the New York Court of Appeals, on which Judge Wesley sat. The odyssey of that case was, it was a 3.5-year odyssey, till it went up to the New York Court of Appeals. And what you see in these boxes, these are, whoops, excuse me, I want to be accurate. These boxes are the exact boxes that went to the New York Court of Appeals on May 1st, 2002. May 1st is Law Day. And in honor of Law Day and the significance of that day, and reflecting the patriotic good government purpose of this lawsuit, we wrapped these boxes in red, white, and blue flag decoration. And inside these boxes is the entire record of the case, from its inception in April 1999 in New York's lowest state court, which is the New York Supreme Court, through the Appellate Division First Department, which is the intermediate court, and then reaching the New York Court of Appeals. This is what was before Judge Wesley. And when I say this was what was before Judge Wesley, I mean this, because this is not a copy of what was submitted to the New York Court of Appeals on Law Day 2002. This is what was submitted, because after the case was rejected for review, I picked up these boxes, and by that time, Judge Wesley had been nominated by President Bush to the Second Circuit Court of Appeals. And indeed, what we believed, based upon a chronology of events, was that the nomination of Richard Wesley was in no small measure a payback for what he did in protecting the government, protecting in particular New York's Governor Pataki, who was implicated directly in the corruption of the Commission on Judicial Conduct and in the events that triggered this extraordinary lawsuit.
So are George W. Bush and Hillary Clinton on the same team, except in separate parties?
They are on the same team because, again, when the president makes a nomination to the federal bench, he doesn't act out of thin air. He acts upon suggestion and recommendation and entreaty of other political figures. One of his key people in New York was George Pataki, New York's governor, and especially so because in 2003 there were no Republican senators in New York. Both New York senators to Congress were Democrats. Charles Schumer, the senior senator, and Hillary Rodham Clinton, the junior senator. So Pataki had a special pull because there were no Republican senators. But as part of that arrangement, it had to be cleared with the home state senators. And once the nomination is made and was made, the home state senators, Schumer and Clinton, each had what is called a blue slip prerogative. They could have, at that juncture, even if they weren't involved in the behind closed door process that led to the nomination of Richard Wesley, they had, at the point he was nominated, a powerful role to play, a powerful safeguarding role to examine the fitness of Richard Wesley and to nix that nomination, to prevent it from proceeding to hearing before the Senate Judiciary Committee, or certainly to slow it down in an appropriate fashion so that it might be properly scrutinized. What I brought to Washington in answer to your question were these boxes, but verifying what Richard Wesley had done in the two public interest lawsuits against the Commission on Judicial Conduct and the second one involving billions of dollars of New York bonds and the way New York goes about its backdoor borrowing and financing, which was at issue in the other case.
They don't want to have a money trail found out, so they have a judge that's complicit.
Well, right. The secret of what goes on in courts is that the law is quite secondary, and the facts also don't count for anything. What you need is the judge, and when you have the judge, nothing else matters. And what we have in our courts too often, and what we have had in New York's highest state court, the New York Court of Appeals, are judges who are going to use their office to protect powerful, vested interests and to completely upend all standards of adjudication and conduct. What was done by Richard Wesley, if I can just give you a little snippet, and indeed, all these files were not needed to verify what Richard Wesley did. It didn't require hours and days. What it required was to verify something that was very easy to accomplish. Because what I provided to Senator Clinton and to Senator Schumer as New York's 2 home state senators, and likewise to the Senate Judiciary Committee, was a written statement that, I think it's the other. Here we go. What I provided was a written statement which laid out, and in fact, here it is. Here's the here's the cover letter to Senator Clinton from April 23rd, 2003. It's entitled Citizen Opposition to Senate Confirmation of New York Court of Appeals Judge Richard C. Wesley to the Second Circuit Court of Appeals. And he was one of 2 nominees that for which we provided Senator Clinton as well as Senator Schumer, Senate Judiciary Committee.
So you did you show up in Washington, D.C. with this?
No, I did not show up in Washington, D.C. What I did first was to provide to Senator Clinton a fact-specific statement identifying what Richard Wesley had done, his misconduct on the bench in these 2 important cases. And what I said is that misconduct is not only verifiable from the file, which I was providing to the Senate Judiciary Committee, but it was verifiable in the first instance and most easily from the final 2 motions in the case at the New York Court of Appeals. Motions that went to Richard Wesley. And that what was needed was only a minimal amount of time to verify what he had done. Now, what had he done? Well, one of the things he had done was he had lied on a motion made for his disqualification. You see, the case against the New York State Commission on Judicial Conduct implicated various members of the New York Court of Appeals and those with whom they had connections, relationships, and a motion was made to disqualify the various judges of the New York Court of Appeals, including Judge Wesley. How did they address that motion? They lied. What they did was, they said, the court lacks authority to entertain the motion made on non-statutory grounds. Which is to say, because you say to yourself, well, what does that mean? The court lacks authority to entertain the motion made on non-statutory grounds. You say to yourself, well, I don't know what that means, but she must have made the motion on non-statutory grounds. But I made the motion on statutory grounds. And the statute was Judiciary Law 14. And that is a statute that relates to interest. And where a judge has an interest in a litigation, he is disqualified absolutely. It's not discretionary. He cannot sit. And the motion that I had made invoked over and again Judiciary Law 14, and it described the disqualification for interests of each of the judges. All you have to do is compare the motion made to the decision on the disqualification issue. And you see that the judges lied. And indeed, I made a motion to the New York Court of Appeals when they rejected the disqualification motion, as they did. I said, it's an outright lie. I made the motion on grounds of interest under Judiciary Law 14. And I pointed out again and again how they were disqualified. They ignored the motion made. They rejected it. That is, any judge can make a mistake. But when you make a re-argument motion, as I did, and you point out, well, wait a minute, I made the motion on statutory grounds, Judiciary Law 14, interest. And they adhere to their original decision, their original lie, the court lacks authority. Well, first of all, that's a bold statement. Why would the court, even had I made the motion on non-statutory grounds, which I did not, why would they lack authority? They didn't cite any law to support that proposition, which is a deceit in and of itself. They would have authority. But the motion was made on statutory grounds. So it doesn't take long. It takes a minute to verify that fact. And then, of course, having disposed of the disqualification issue in such a fraudulent way, they rejected review of the case. They refused to hear the case, where I showed that there was an appeal of right because of the transcending constitutional issues entitling, as a matter of law, review of the case. And then beyond that, I showed that what was at issue in the case was the corruption of the New York State Commission on Judicial Conduct, which was shown by the record to have been the beneficiary of a succession of fraudulent judicial decisions, both in this lawsuit and in other lawsuits, without which it would not have survived. So this was an extremely important case, but the threshold issue was that Judge Wesley had lied on a motion for his disqualification. He had lied in this case, and he had done the same thing on the other public interest case to which I referred, involving billions of dollars of New York bonds. Well, Senator Clinton is a lawyer. She is a Yale Law School graduate, and she knows how to make findings of fact and conclusions of law with respect to a particularized written statement which provides the evidence of misconduct, of corruption in office by a nominee that is going to be confirmed to a lifetime federal judgeship. Instead of reviewing this evidence, which was her duty, she did not respond other than through her legislative correspondent and her counsel, with whom I had a phone conversation. And this was a phone conversation of roughly 35 minutes. And neither of them had, this was a phone conversation that took place 2 days before the scheduled hearing on Richard Wesley's confirmation. Neither of them had read the written statement, let alone the underlying dispositive two motions, and certainly not the underlying
Those are
file.
on your website. Please let me know what that is again.
The website is www.judgewatch.org, and what I'm speaking of right now is the disruption of Congress case. And there is a sidebar panel that says disruption of Congress, and you can see the paper trail to jail. And what the paper trail to jail shows is the succession of correspondence that I had with Senator Clinton's office, Senator Schumer's office, the Senate Judiciary Committee, and what you see on the site is a letter of May 21st, 2003, where I set forth to Senator Schumer what had taken place in the telephone conference that I had with Senator Clinton. And I sent a copy of that letter to Senator Clinton. Can we, because I want to, so, okay?
All right, go ahead.
Well, maybe you should take the plate away. We don't want people to know that I eat while I'm working. Okay, so you were asking about what happened in the conversation, because I had a telephone conference with Senator Clinton's office staff, her counsel and legislative correspondent. This was just a couple of days before the Senate Judiciary Committee hearing, 2 days before the Senate Judiciary Committee hearing on the nomination of Richard Wesley. The counsel and legislative correspondent had each not read the written statement that I had prepared setting forth the misconduct in office of Richard Wesley and the evidence substantiating that misconduct, that corruption in office. They admitted that they had not examined the underlying documentation, even those two motions which sufficed in and of themselves to establish Judge Wesley's misconduct. Nonetheless, they told me that Senator Clinton would not oppose the nomination, that she would not even endorse my request to be permitted to testify in opposition. They refused to give Senator Clinton the written statement so that she herself could read it and verify for herself its seriousness. And their position was that no, that confirmation was going to proceed. Their behavior was so shocking. After all, they had not examined the underlying documentation. They had not read and admitted to it. They clearly had not read the statement itself. And yet, they were going to allow Judge Wesley to be confirmed for a lifetime federal judgeship, knowing that he had corrupted his office as a New York State judge. After the conversation was over, I thought about what I should do. And after about an hour or two, I concluded that what I should do is to call up Senator Clinton's office and to speak to the Chief of Staff as to the misconduct of the Senator's counsel and legislative correspondent. I left a voicemail message. It was late in the day. I got no call back, and the following morning, which was now just the day before the hearing was to take place, I called once again and to speak to the Chief of Staff. And once again, I got a voicemail and left a message requesting a call back as soon as possible because the hearing was to take place the following day.
And that's in Washington, D.C.?
In Washington, D.C.
And what was the approximate date?
The date of my telephone conference with the Senator's counsel and legislative correspondent was May 20th. I called...
What year?
2003. I called at the end of the day to speak to the Chief of Staff, left a message, and the following day, May 21st, I left a message. And did I get a call back from the Chief of Staff or some other staff member of Senator Clinton's office as to the misconduct that I was reporting of these important staff members? No. Instead, I got a call from Capitol Police. And Capitol Police told me that they were calling at the instance of Senator Clinton's office, that Senator Clinton's office had called them, and that Senator Clinton's office purportedly didn't understand why I was calling, and framed it as if I was somehow harassing the senator.
How do you harass a public official if you're trying to report corruption?
Well, I certainly was not harassing the office. There was no way it could be interpreted as harassment. And I told the Capitol Police, it was the threat assessment unit that called me, I said, well, they know very well why I am calling. I am calling to complain about the misconduct of the Senator's counsel and legislative correspondent, who have not even read the documents germane to the issue of the fitness of this nominee, who is slated for a Senate Judiciary Committee confirmation hearing tomorrow, the next day. Capitol Police threatened me that if I came down to Washington and requested to testify, because I said to them that Senator Clinton's office would not even endorse my request to be permitted to testify, and that I had requested of the Senate Judiciary Committee without any response to be permitted to testify. Capitol Police threatened that if I came down, they asked, is it your intention to come down? And I said, yes, it is a public hearing, isn't it? And they even asked me, well, are you coming by train? What train are you going to be on? As if they were going to apprehend me at the station.
The Capitol Police were trying to terrorize you out of testifying in a public hearing?
Surely were.
And it's Hillary Clinton. Do you think that her fingerprints are on it? Do you think that...
Do I think? They told me. They told me that the reason for their involvement was because they had received this communication, phone call, from Senator Clinton's office. And Senator Clinton's office knew full well, I should say, that so devastating, apparently, or so discrediting of the deceit, so discrediting of Senator Clinton's office. I haven't been able to say what I'm trying to say, because what I'm trying to say is actually fast forward the story, because as I indicated, I left 2 voicemail messages for Senator Clinton, Senator Clinton's chief of staff, complaining of the misconduct.
Who was the chief of staff?
The chief of staff was Tamara Lozado. The counsel was Licia Eve, and the legislative correspondent was Judge Albert. But to fast forward the story, and to show you how the evidence was destroyed of what actually happened here, is that ultimately, when I was brought to trial, it was revealed on the witness stand by Capitol Police that they couldn't find the recording of the recordings of my voicemail messages to Senator Clinton's office, which were clear and concise as to why I was calling, which was, again, to complain of the misconduct of counsel and the legislative correspondent on such a serious matter.
So do you think Hillary Clinton was complicit in wrongdoing?
I immediately, the answer to that question is yes, because I immediately, upon being threatened by Capitol Police, I immediately set forth what had happened. And I provided a letter, I sent a letter to Senator Clinton, and I said in it that I again beseeched her to review the written statement of opposition as well as the related memoranda that I had written about what was going on at the Senate Judiciary Committee, because the Senate Judiciary Committee was likewise derelict, was notwithstanding all the boxes had been delivered to the Senate Judiciary Committee, as well as the key two final motions, I received no return call from the Senate Judiciary Committee. Nobody inquired with any questions as to further particulars as to what Judge Wesley had done. No inquiries made, no findings of fact, no conclusions of law.
So you're trying to make a complaint against a judge.
Well,
and then what happened?
Well, what happens is when you provide that information to the Senate Judiciary Committee, when you provide that information to home state senators such as Senator Clinton, it falls into a black hole. It's as if you haven't presented anything. They just ignore it, full speed ahead. And what I said in my letter to my follow-up letter to Senator Clinton was I again beseeched her to examine the written statement that her staff was refusing to give to her so that she could make her own determination as to its seriousness, and give her as well the other correspondence that I had had with the Senate Judiciary Committee showing that they weren't doing the job that the public expects them to do, which is to examine evidence of nominee unfitness.
So did Hillary Clinton know that you'd...
Well, the final sentence of the cover letter transmitting this, and it was both faxed and emailed for emergency attention, was, "This is surely a story for Senator Clinton's New York constituents, as well as any citizen who might passingly consider voting for her in a presidential run." That is, public needed to know at that time, I said, as to how she is betraying the interests of her constituents. The interests of her constituents are not well served when a judge who has corrupted his office as a member of New York's highest state court is then elevated, promoted to the powerful federal court, the Second Circuit Court of Appeals, which covers New York,
Judge Wesley,
and Connecticut, Judge Wesley. Now, what happened is that notwithstanding, I provided Senator Clinton in subsequent cover letters, this cover letter as well as other correspondence, with the information as to the misconduct of her staff, as to the failure of the Senate Judiciary Committee and her office to have any findings of fact and conclusions of law as to Judge Wesley's misconduct. She showed up at the Senate Judiciary Committee hearing and testified glowingly on behalf of Richard Wesley, as did likewise Senator Schumer, who had received the identical information and documentation. At the end of their presentations, there was a recess called, and they left. All the senators left except for one senator of the Senate Judiciary Committee, Saxby Chambliss, who presided. And he then fielded, after they had Senator Clinton and Schumer had given their testimonial presentations on behalf of Richard Wesley. Senator Chambliss presided after the recess as the only senator present and tossed some soft questions to Judge Wesley, the equivalent of, do you believe in God and apple pie? 3 absolutely trivial questions, not asking anything about the citizen opposition, written citizen opposition, which had been provided to the Senate Judiciary Committee, and which we had requested be the subject of interrogation of Richard Wesley. At the end of this charade, Senator Chambliss announced the hearing adjourned. And I was in the back row, and I had waited to see whether or not Chairman Chambliss, presiding Chairman Chambliss, would ask whether anyone present had any opposition to present, whether anyone wished to be heard on the subject of the nomination. Because after all, it's like a marriage. Speak now or forever hold your peace. Because otherwise, he's going to be confirmed to a lifetime federal judgeship. In the past, I had pointed out in prior correspondence,
Hillary Clinton.
Hillary Clinton, to Senator Schumer, to the Senate Judiciary Committee, that there had been a practice, or it would seem there had been certainly occasions when the presiding chairman of the Senate Judiciary Committee had inquired at the hearing, is there anybody who wishes to be heard? And I had said in response to the threat that I would be arrested if I requested to be permitted to testify, I had said, well, I would expect and hope that the presiding chairman would inquire without my having to ask to be permitted to testify. I would hope that he would inquire whether anyone wishes to be heard. But if he did not do so, then yes, I would request to be permitted to testify. And I waited so long for to hear whether or not the inquiry would be made. Is there anyone present who wishes to testify on this nomination? That before I knew it, presiding Chairman Chambliss announced the hearing adjourned. And it was then that I rose from my chair. And I was so nervous because, after all, I had been threatened with arrest. And
for free speech.
For the free speech of requesting to be permitted to testify. So I wanted to be sure that I said what needed to be said, and I didn't mess. Oh, can you? Because I want to get. I wrote it out, and I want to. I mean, this is such an. Is it in here? Yes. I'm sorry, I had to get up. And I already identified I'm not ready to do it. Okay.
All right, go ahead.
Yes, so I had been threatened that I would be arrested if I requested to be permitted to testify. Respectfully requested to be permitted to testify. And needless to say, I was so nervous at that prospect that I wrote out what it is I needed to say, because I was fearful that maybe I would be jumped. And I wanted to be sure that I got it out and I wasn't going to fumble. So there's no question as to what it is I said. Because I stood and I read from the sheet of paper that I held, and this is the sheet of paper. And I said, my exact words were, Mr. Chairman, there's citizen opposition to Judge Wesley based on his documented corruption as a New York Court of Appeals judge. May I testify? And for that respectful request to be permitted to testify, not even made until after the hearing was already announced adjourned, I was taken out by Capitol Police, arrested, held over for arraignment the next day on a completely bogus, trumped-up disruption of Congress charge.
If the meeting was adjourned, how could you disrupt them?
As a matter of law, it could not be. And I should say that what I did is not he said, she said. It is verifiable. There was a stenographer taking down the proceedings, but even more importantly, there was a videotape. And I immediately requested a copy of that videotape. And when I saw the videotape, when I saw the videotape, I saw what happened when I was taken out. Now, before I was taken out, you see precisely what I said, which is that Chairman Chambliss had already announced the hearing adjourned. And then I spoke, and I said what I said, which, and you will see that after I said, may I testify, I didn't say another word. But Chairman Chambliss, can I'd like to have a transcript in front of me so I can...
Go ahead.
Okay.
It's a snap to... No, it's okay.
What a mess you have here. So, after I asked, may I testify, Chairman Chambliss says, I will issue a warning that we will have order. The committee will stand in recess until the police can restore order. Everyone remain seated. And you would think that there's some commotion, but I was completely silent. And only when the police sought to remove me did I call out, are you directing that I be arrested? Because my position was, when I spoke with Capitol Police, that they couldn't arrest me. It was the decision of the chairman as to whether or not I should be arrested for a respectful request to be permitted to testify. I was taken out, and after I was taken out, as I said, I subsequently obtained the videotape. And from the videotape, you see two things. First of all, you see that upon my asking whether I might be permitted to testify, Chairman Chambliss's face doesn't show any surprise. Instead, you see him reaching for his reading glasses and pulling a paper. And then the camera backs off his face, so you can no longer see his face. I'm taken out, and then you can tell from the tempo of what he says that he is reading a script. He is reading a prepared statement, which was, outside witnesses are welcome to submit letters supporting or opposing nominees for the committee's consideration, but it is not our usual procedure to invite outside witnesses to testify either in support or in opposition to the nomination. I realize that this lady is disappointed that she is not able to make any statement this afternoon, but her disappointment in no way condones any disruption of this hearing. Again, we stand adjourned. In other words, he knew that I was coming. He could have made that statement before I rose to request to be permitted to testify. He knew my position, that my position was in written correspondence, that if there was no inquiry as to whether anyone wished to testify, I would ask. But rather than say, well, we are aware that there is someone who wishes to testify, but it's not our custom,
So there was a conspiracy.
I was set up.
Conspiracy to put you in jail.
I was set up, and this was made known subsequently to Senator Clinton that I had been arrested for disruption of Congress. The charge was completely bogus, trumped up, malicious. She took no steps to prevent this prosecution.
You had just written a letter to Senator Clinton exposing the corruption of Judge Wesley. So instead of taking the information or trying to investigate it, she sees to it that you're put in prison for 6 months?
She set in motion the train of events that led to my arrest on a completely bogus charge, as she well knew. Her obligation and the obligation of the other senators and the committee was to examine the evidence presented and to make findings of facts and conclusions of law as to whether Judge Wesley did what I asserted he had done, and whether or not this was not evidence disqualifying him for any office of public trust, certainly for a Second Circuit appellate judgeship. Not only that, Senator Clinton allowed her staff, ultimately, after I was railroaded to trial in a court that is directly under Congress, funded Congress, and that completely violated my rights. I had made I had brought a subpoena for Senator Clinton's testimony at trial, so that she could account for her conduct and what she knew and when she knew it. I brought subpoenas for the testimony. You want to hold it so that we can...